Hi everyone, you're watching the virtual Amicus and I'm Jay Lodha. So today's topic for discussion would be on arbitration essentials, an overview of key concepts, practices, and emerging trends. So joining us today on the virtual Amicus is one of the most respected and prominent lawyers, barristers in this field of arbitration. He's also called the doyen of the international arbitration as well as domestic arbitration, undoubtedly one of the most brilliant minds in this field. And so we are in conversation with Mr. Mikhail Behl. And just to give you all a brief introduction about our Amicus for today's session, he enrolled as an advocate in the year 2007, qualified as a barrister in the year 2023, designated a fellow FCI arbitration of the Chartered Institute of Arbitrators UK, fellow FICA of the Indian Council of Arbitration ICA, and fellow FPD of Prime Dispute UK, mediator of the Society of Mediators in UK. Now, as far as experience is concerned, it's a rich experience is concerned. He's also the recipient of Prime Disputes Dispute Resolution Award, Asia 2024. He has over 100 sole arbitrator appointments in both ad hoc and institutional arbitrations, 3 appointments as member of a tribunal, 2 appointments as a presiding arbitrator, 8 appointments as a mediator in commercial disputes. He's also impaneled as an arbitrator with the host of arbitral institutions such as SIAC, DIAC, HKIAC, ADGM, ICA, IIAC, MCIA, and the list goes on and on. He has over 30 reportable judgments too, 10 notable publications on a variety of arbitration-related topics, and published in various legal publications with article on costs being part of the curriculum for the training of commercial court justices at the National Judicial Academy, and an article on third-party funding in arbitration being the recipient of an award at the 2022 HK45 essay competition. He's also an author of a newsletter on arbitration, deliberations with a readership of 85% against an industry average for similar newsletters of 20 to 30%. Wow, what an introduction. Indeed, and doyen of arbitration. Thank you so much, sir, for taking out time. I know it's a Saturday afternoon, but it really means a lot that you took out time and you chose this very important topic, which is arbitration essentials, an overview of key concepts, practices, and emerging trends. Anything that you wish to say about our channel before we can start with your session?
Hi, Jay. Thank you for having me. I've been following your channel for a while now, and I think it's making a significant contribution towards not only legal learning, but also changing the way we perhaps learn. And I think long form communications will perhaps be the future of legal learning.
Grateful, sir, for all the kind words. Really means a lot. So can't wait for the session to begin. Let's quickly start with the session, sir. If you're
Sure.
ready, if you can start with the PowerPoint presentation.
Sure. So the topic that I'm going to be covering, Jay, is basically an introduction to some of the key practices and concepts in arbitration. I'll also assess in passing some of the emerging trends and perhaps strategies that we adopt in some of the emerging trends in arbitration. So basically, let's start at the basics. What is arbitration? Arbitration is a private dispute resolution mechanism. The parties agree to refer their dispute to a person who is described as an arbitrator or a tribunal of 3, maybe more members. This is an alternative to going to court to adjudicate your disputes. So the decision of this tribunal is binding. It has the same effect and is of the same character as a decree of a court. It is just an alternative to court proceedings. Why you would perhaps choose arbitration is because it is a faster route to attaining a result, which is very meaningful to persons engaged in commercial sort of disputes. They want a quick resolution of those disputes. You would have 2 options here. One is you would go into what is known as ad hoc arbitrations. These are arbitrations where the arbitrator is the administrator of the dispute, as opposed to an institution. Where you have an institution administering the dispute, we call those kind of arbitrations as institutional arbitrations. And I've in this slide, I've referred to an interesting case law of the Supreme Court, where the Supreme Court was confronted with a perhaps faulty arbitration mechanism, which failed to mention the institution the parties had desired to refer their dispute to, and meaningfully interpreted to mean necessarily the Singapore International Arbitration Center, given the particular facts and circumstances of that case. So why would you choose ad hoc arbitration? You would choose ad hoc arbitration because A, the cost would be, well, some say efficient. We will discuss this a little further. You would have a role to play in the appointment process. So you would have the choice of A, nominating or suggesting the nominee. And it is only when there is a failure of the mechanism that you would approach the court at the seat to fill up that vacancy. You would also have a role to play in removing or substituting the arbitrator. You would have procedural flexibility in the sense that as you progress in your arbitration, you may have several issues that arise, and you would have a role to play in deciding what is the best procedure to address those issues. That flexibility may perhaps not be available to you in an institutional arbitration, because usually institutions have their own set of rules, and you would be bound by those when you submit your dispute to them. You would have court assistance at 3 stages, that is pre, pending, and post the arbitration. Pre, you would have the assistance of the court in constituting the tribunal if the mechanism fails. Pending, in the collection of evidence and enforcement of interlocutory orders. And of course, post the arbitration, most parties, whether they choose ad hoc or institutional arbitration, end up in courts for challenge proceedings, set-aside proceedings, or enforcement proceedings. You would, of course, have a right to appeal against the award, and that would again be something that's available to you in ad hoc arbitration. So broadly stated here, the advantages are your participation in the process and the flexibility of the chosen process. Coming to institutional arbitrations, you would choose institutional arbitrations because they have a defined body of rules. These body of rules prescribe streamlined processes. You could have documents-only arbitrations, which of course is also available to you in ad hoc arbitrations, but are more stringently applied in institutional arbitrations. You would have procedural certainty because all stages and exactly what is going to happen at each stage would be defined through the rules. You would have an identified panel of arbitrators, usually specialists in particular fields within the realm of arbitration. So for instance, you would have a known body of experts in, say, construction arbitration or insurance arbitration or admiralty arbitration. You would have secretarial support. Usually these large institutions would offer you a tribunal secretary to assist you in through the course of the arbitration in managing some of the more administrative aspects of the arbitration. You would, of course, also have a designated case manager. That's another asset which usually assists the parties and the arbitrator in fulfilling all administrative stages during the course of the arbitration. So the arbitrators and the parties can sort of concentrate on the matter before them in that sense. You would also have another stage, which I think can be very vital depending on the institutions and the roles that they wish to play, is vetting the award. Vetting the award is a stage where the arbitrators have prepared a draft of the award, and they then tender that over for vetting to the institution, and the institution would internally assess the award for any procedural defects or logical inconsistencies, perhaps, which would render that award open for challenge at a subsequent stage. So it's kind of a 2-stage pass on the award before it's actually issued, which I think is quite a valuable contribution. This is a question that I think logically follows from the introduction to the two sort of mechanisms. Well, each mechanism has its advantages, which we've just discussed. The disadvantages are also sort of, they draw parallels, but they're not necessarily identical. The disadvantages of ad hoc arbitration would be primarily the cost can become uncertain in some proceedings. So you may have a delay occasion because of not having defined your procedural rules in the arbitration agreement. So you're basically building as you go the procedure to meet your needs, and that results in extra hearings, uh, clarifications, things of that sort, and leads to cost overruns. You perhaps need court assistance. So additional proceedings not contemplated initially, leading again to cost overruns. If you draw a comparison with institutional arbitrations, the institution probably has procedures laid down, and the arbitrators would therefore just follow those procedures, and parties would be mindful of those procedures, even perhaps before invocation. Um, you may also have the additional disadvantage of expenses in connection with the administrative charges and secretarial charges that some institutions impose, and of course the difficulties associated with, for certain parties like state parties, in meeting the timelines set by these procedural rules in institutional arbitrations. So it's a choose your poison kind of situation. You choose what's perhaps the best available option for you at the time when you're drafting the agreement, of course, not at the time of the dispute, because that's too far down the line. You make these decisions prior to contractual relations even beginning, and each has its positives, each has its negatives, and you live with those consequences later. These are the known consequences. Why you would definitely choose arbitration over litigation, of course, is another question you would ask yourself. You would choose arbitration over litigation because no matter which option you chose, whether it was ad hoc or institutional arbitration, you would almost certainly have an award prior to the best case scenario in a civil dispute in a court of law. I think that's fair comment. It might sound a little harsh, but I think that's fair comment. You would also have a very defined understanding, or uh, a good understanding of the cost that you're going to incur in the prosecution of these proceedings. You, of course, have the great advantage of having confidentiality, and sometimes, whether depending on the nature of the dispute, parties would perhaps not want to have their issues highlighted in a public forum like a court. So this could be anything from family disputes to shareholder misunderstandings to something perhaps involving an IPR dispute where you don't want to divulge your trade secrets or your business strategies in an open court proceeding where they can be accessed or are available in the public domain for someone else to sort of come to learn of. You would, of course, also have this great advantage. And again, this might sound like a harsh criticism, but it's not a criticism at all. Arbitrators specialize in particular areas of law, whereas judges get assigned matters through the master of the rolls of their particular court. What that necessarily implies is expertise builds within the sort of arbitration bar and practitioners at the arbitration bar, both as arbitrators and counsel. And that's perhaps the biggest failing of the court system, is that we don't have judges who are allowed to specialize in only a particular area of law throughout their course as their tenure as judges, rather. What that consequentially results in is a higher error rate, a higher cost, because you have a judge who, well, legitimately is allowed to learn the law so that he doesn't make an error. And cost overruns associated with that. The last advantage that I think arbitration has over the court proceedings is the limited grounds of challenge. So you've had an expert potentially decide your dispute, and the grounds on which you can then challenge that expert's conclusions are limited by statute or by rules available to applicable to the dispute. Of course, though I gave an overarching sort of view previously, there are also certain circumstances where you may prefer litigation over arbitration. Obviously, the first and primary consideration is whether the subject matter of the agreement that involves or contemplates arbitration is a subject matter that can be referred to arbitration. So if it involves a dispute in rem, so something like a mortgage proceeding or ownership of IPR rights, testamentary matters, these can't be referred to arbitration as per our present legal sort of framework, and therefore they must go to courts. If you have a dispute arising out of an agreement that is so novel that it is going to set precedent, it would be ill-advisable, or perhaps another way of seeing it is you are quite mindful of the fact that these proceedings are going to set legal precedent. The confidentiality of arbitration then sort of hampers that process, because the decision-making processes within arbitration are not perhaps the best processes for deciding novel cases. It is a good process for deciding well understood law, and experts therefore are suited to that particular task. But when it's a novel case, I think our court systems are the best suited option there. Arbitration is perhaps not the best option when you are quite mindful of the fact that your opponent or your opposite party is someone who is going to be very, very difficult to enforce a judgment against. In those circumstances, you should be mindful and perhaps not have an arbitration clause, have a court reference, so that the sort of more coercive mechanisms available to you through court to not only make a party appear, but also to comply with orders of the court are available to you at your disposal. And unfortunately, arbitration doesn't have those remedies. You would have to go back to court, and that kind of leads to a cost overrun in any way event. So it's something that requires a little bit of foresight and anticipation. But if you anticipate those circumstances, you would possibly choose court over arbitration, in my opinion. Strategies to make ad hoc arbitration more efficient is what I'm covering here. Imagine a situation where the mechanism does not work out. You would have to go to a court and have the vacancy of the arbitrator or arbitrators filled up. I propose that naming an arbitrator, that is selecting a domain expert perhaps, in the arbitration agreement itself, is a great way of avoiding a failure of a mechanism. So what this also allows you to do is you can engage with a person who both sides have a fair degree of trust, confidence in, a person who is obviously skilled in the particular area of law that you're concerned with. And of course, you've begun your process immediately. So you've saved on time, you've saved on costs, and I think it's greatly advantageous. I've noted a particular case that I had the opportunity of appearing in the High Court. This was a case where the late Nani Palkiwala was the named arbitrator. And when he passed away, there was a dispute between the parties, and the courts all interpreted the agreement to mean that a substitute with similar qualifications could be appointed as the arbitrator. So I've cited it not for any other reason, but to show you that even when there is an impossibility in naming, in appointing the named arbitrator, the courts will fill up that vacancy. So this is quite a foolproof clause in that sense. Another strategy you could adopt is adopting the procedural rules of various what we call soft laws. So the UNCITRAL model law, or perhaps even the institutional rules of particular arbitration institutions with modifications, of course, to make it sort of applicable to ad hoc arbitrations as opposed to institutional arbitrations. And I've quoted a colleague of mine's article on this, and I think it's quite insightful in how he has contributed to how adoption of UNCITRAL ad hoc rules could benefit an ad hoc arbitration and save time and sort of quicken up the process and make it super efficient. I think choosing a seat is also another vital decision. There are certain forums, certain courts in India that I think have a very successful or a very prolific rate at which they are deciding questions that arise out of arbitration. And of course, you can't create artificial jurisdiction, but if you could perhaps bring it within the jurisdiction of those forums, and their turnover rate being so attractive, and you would perhaps want to choose a forum that is a vibrant forum and a good seat pro arbitration, so that it aids your process when the need arises. So now here we come to a new sort of development in arbitration. These are known as multi-tier clauses. So why would you have a multi-tier clause? You would have a multi-tier clause where parties have a long sort of business relation or personal relation, and you don't want to turn it into an adversarial sort of situation of the at the first instant of a problem. So you want to explore sort of a reconciliation process. So you would possibly include in your dispute resolution clauses a multi-tier framework. So a multi-tier framework would be a combination of negotiations, mediations, arbitrations, perhaps even adjudication. Depending on the nature of the agreement, you might have sort of a domain expert giving an evaluative assessment as well. So what these clauses do, in my opinion, is they allow parties to avoid sort of the boiling point of the dispute as long as possible. So it is advantageous in that situation. They've had sort of a mixed reaction in our courts. Some courts believe them to be mandatory steps. Some courts sort of look at them as avoidable steps, depending. A lot of it just turns on the facts and how parties have behaved with respect to these clauses, I believe. And I think the most logical outlook is the party that frustrates the tiers from the multi-tier clause from operating should not be allowed to take advantage of it at an appropriate stage. So I think the case laws that I've cited also suggest that you can always approach court for assistance in interlocutory relief and of course in evidence collection, even while exploring these processes. So you could be in a mediation and secure an injunction requiring your opposite party to provide you with evidence, so that that evidence is not destroyed for the purposes of the dispute just because the mediation is proceeding. So courts have taken a very meaningful, albeit not final, conclusion on these clauses. So how do you start the arbitration? You start the ad hoc arbitration process by issuing what is known as an invocation letter. Now, our courts have set out rather what they believe are necessary contents within these invocation letters. And I've cited some of the law on that. Uh, so it's a mixed bag approach. You'll find one court saying that all you need to do is seek a reference or invoke that particular clause. And you'll find another judgment saying details need to be mentioned. Now, what is my view on it? I'll share my view. Obviously, it's not binding on anybody, but I'll share my view. I believe arbitration is meant to not be the formalistic process of court, and necessarily that understanding or that overarching principle requires you to have a very flexible interpretation of invoking the whole process itself. So introducing or insisting on certain formalities to be met, I think defeats the process, because if the rules of procedure and evidence only guide the process and don't bind the process, then insisting on rigorous formalities of the invocation letter should also not be um, appropriate standard for assessing the correctness or otherwise of an invocation letter. So what is the importance of the invocation process? The importance is that once this letter is received, it stops the running of limitation. And this is because the issuance of that letter is deemed to be the beginning point of your arbitration. So your process has started. Your mechanism may fail, and you may have to approach court for appointing the tribunal, but the process has started. So this is a very mindful introduction in the act, because if it was any other way, you could defeat a claim just by delaying the appointment of a tribunal. So that's the reason why we have this provision, and that's the importance of the letter, in my opinion. It stops limitation is the importance. It should not have to meet uh, a very rigorous standard. It should just suggest arbitration as being the chosen process here on forward. Now, how would you commence in an institutional mechanism? So I'm here now drawing you into a case study where I analyze MCIA's process and how you would go about starting a claim before the MCIA. So the MCIA requires you to write to their registrar through a written request for arbitration, and it does require you to provide certain information. So that information involves you giving a brief statement of the dispute. It requires you to quantify your claims. It requires you to state the reliefs that you are claiming. So this is not something that can be done casually. It is a quite mindful process. It also seems to be a quite definitive process, because once MCIA accepts this reference to for arbitration, I believe that is the claim that can be decided thereafter. So it should also, of course, provide the details of the persons with whom MCIA will thereafter correspond with as the respondents, so that they can be served with notices and things of that sort. With the arbitration agreement, so that they are quite confident that MCIA does in fact have jurisdiction over the dispute and can administer it. You would have the option of nominating an arbitrator, whether it is a sole arbitrator or a tribunal of three. MCIA's rules, however, allow it to decide on whether your choice of nominee is appropriate, given the nature of the dispute, given the nature of the claim, and of course, they will exercise that at this stage when they receive your reference for arbitration. Once you've, of course, paid their administrative fees. Um, Yeah, I think that's about what we need to cover for the MCIA process. There's also another recent, well, it's not recent, it's now more sought after. The process of initiating an emergency arbitrator. Um, so here I've analyzed SIAC's rules because the two landmark cases that perhaps people in our jurisdiction are familiar with both arise from SIAC rules and an emergency arbitrator acting under those rules. So here you would issue what is known as a notice of arbitration. You would address it to the registrar. Registrar forms a prima facie view that an emergency does exist. They will refer it to the president, who would appoint an arbitrator within a day of receipt of the notice of arbitration. Now, the notice of arbitration again requires certain particulars, and it would again require you to give a brief assessment not only of your case, the merits of your case, but also why you are entitled to relief on an emergency basis. So it's almost like an equivalent of, well, in Bombay, we call these interim applications for injunctions or something of that sort. So you would state your emergency, you would state why your rights are likely to be defeated if this step is not taken by the institution at this stage. So it's very akin to that. So that's a good way of sort of drawing a parallel there. You would pay the emergency arbitrator fees, and two very well-known cases are, of course, the Amazon and Future Retail case, and a very interesting, very interesting case between HSBC and Avitel. The plot of which is as good as any Bollywood film you'll ever come across. It is an outstanding case of, well, the arbitrators and the parties, an outstanding fraud that is perpetrated on a very large bank. So yeah, those proceedings are still at large and pending in the Bombay High Court for execution. Though, of course, the emergency arbitrator's award in favor of the bank has been given effect to right up till the Supreme Court. So reliefs have been granted. And I believe that a large part of their claim is protected through those orders. So that's a case of identifying a situation where, in a very egregious case, the emergency arbitrators award sort of came to the immediate sort of help and assistance of a claimant who would otherwise not have realized any money had they waited for the arbitral tribunal to be constituted and then approach the arbitrators for relief. So I've got some data which I wanted to share with you all about. Copyright to everybody whose data I've borrowed here, but this data is quite illustrative and kind of explains how people make their choices with respect to choosing various options. So this first slide is a slide that covers construction arbitrations and data collected as on mid 2023. You will find the top choice is ad hoc arbitration at 30%. So I found that very interesting because construction arbitration is an expert domain, and parties are choosing to go to an arbitrator without the assistance of institutions. So obviously, ad hoc arbitration does not necessarily mean a lack of procedural effectiveness. Parties may be choosing ad hoc arbitration also for the additional benefit of it offering perhaps lower costs. So I think there is something more in this data than, you can just capture from a reading of it, but I think it suggests this. Then you have, of course, the ICC, which is, well, one of the largest institutional forums in the world. And then you would have the American Arbitration Association, and it is a prolific association. Like they have, in this data, they've only captured the construction arbitration aspects of it. But I believe this is the most prolific arbitration institution in the world with disposals of around 80,000 awards a year. So it's a phenomenal phenomenally sort of successful arbitration association. You have ICSID, which would be, of course, construction-related disputes, but arising out of sort of investor-state relations. And you have very happily there the Delhi International Arbitration Center, which I think has undoubtedly done the best sort of work in institutional arbitration in India. Then you have the other forums following thereafter. So this is another sort of breakup of how institutional arbitrations have within themselves done. This is a case filing sort of data. So you can see the amount of cases that they get annually. And unfortunately, I don't see any Indian sort of institution in the top sort of few, but hopefully in the near future we should be there. I think ICC sort of dominates this forum, though I don't think they've got data from the American Arbitration Association captured here, because I don't think the brackets are big enough to capture the amounts that they are doing annually also. So this is data from the MCIA. MCIA's last report. They've now crossed 100 cases as per their social media posts. They haven't yet come out with the reports for this year, but they do about now on an average 25 cases a year. So that's quite promising, I think, for institutional arbitration in the city of Bombay, though they have a long way to go to catch up with the Delhi International Arbitration Center. And this is their category of cases that they largely do. So you'll find energy arbitration and general commercial litigation sort of dominates the field, with construction arbitration being the third. I think service, I don't really know what kind of disputes, maybe former employee sort of bond related issues. So those will be, I imagine, very low value sort of claims. I would honestly categorize share purchase agreements with general commercial litigation. And so you have about that being the dominant sort of nature of disputes that they handle. So yeah, that's the brief slideshow that I had for you all.
Well, thank you so much, sir, for putting in so much effort for all the viewers and explaining everything with the help of a brilliant PowerPoint presentation. To all the viewers who are watching, I request you all to maintain a separate arbitration diary and pen down all the judgments, all the citations and rulings that sir has placed reliance upon and mentioned in every slide. I'm sure it'll be a wonderful learning exercise, and I'm going to do that right away as well. So, sir, if you have the time, can we proceed with the Q&A session?
Yeah, absolutely.
There are certain questions that I had, so I thought that if time permits, then we can go ahead. So question number one coming your way: what are the essential ingredients to draft an effective arbitration clause in an arbitration agreement?
Right. So I have a very pro arbitration sort of mindset here. And what I believe is an effective clause is the clause that works for the parties in any given situation. So I hesitate to sort of define what is the perfect clause, but these are the general things that you would keep in mind. The first thing that you would keep in mind is the scope of what you would want to refer to arbitration. Now, the reason why you would enter into that sort of exercise is because not everything can be arbitrated. So if you have, say, a loan transaction that also has a mortgage created, you are allowed to proceed in arbitration against the debt, but not against the security created by the loan transaction. So you would not be allowed to have a catch-all clause in those situations. You would have to cull out this sort of this breakaway of the debt and the security, and you're allowed to proceed against the debt in the arbitration. You would, again, in insurance contracts, you would find a very common sort of exclusion of or a reduction in the scope, most insurance contracts don't allow repudiated claims to go to arbitration. So insurance contracts being contracts of utmost good faith, insurers are allowed to repudiate claims where they believe that the insured has not been absolutely forthcoming with them, and that the claim is perhaps fraudulent, or the insurance contract itself was procured for fraudulent purposes. So those are all repudiated claims, or generally, those are the two general reasons why you would repudiate a claim. So again, now that kind of ties up with our understanding that very serious cases of fraud should perhaps not go to arbitration, and they are better suited for court proceedings. So you would carve out, and I don't think you have a choice. Insurance contracts are usually sort of these boilerplate agreements. The insurance company would carve out that sort of exclusion there. So that's the first sort of thing that you would keep in mind. The second thing that you would obviously keep in mind is your choice of law. So, and your choice of seat. So the reasons why both of these are important is if it is, say, a cross-border dispute, you would want your rights to be defined by a particular body of law, rather than having a situation where the arbitrator has to, during the course of the arbitration, build an understanding or decipher from the provisions available to him, or the mechanism that is referred to him, what is the actual applicable and appropriate law. So a well-defined, well-framed clause helps there. You would most definitely want to choose between ad hoc and institutional arbitrations, and so that would be something that you would cover there as well. You would have to mention the composition of the tribunal. So whether it's sole arbitrator, panel of three, and the law governing the contract as well as the arbitration agreement. Um, some people include, now recently I've seen this, upper limit on what can be acceptable costs. So this is a novel thing. I don't know if it's reached court and been assessed, but I can see it happening certainly in government contracts, where governments want to limit their exposure to cost orders in awards passed against them. I can see that being sort of an emerging trend and an evolving trend there. Uh, you would there's usually this requirement that you mentioned, that there is finality to the award and the language in which you wish to proceed in those proceedings. So if you are looking, of course, for good sort of collection of draft clauses, there's two very good resources, in my opinion. The American Arbitration Association has a whole body of clauses, like potential clauses for various kinds of disputes. So like, you would have clauses for patent disputes. Patent disputes can be arbitrated in America. So anything from there to trust disputes to IPR to any kind of commercial sort of agreement that you can even imagine, it's there. There's like 30-40 clauses up in their website. And of course, Chartered Institute of Arbitrators has a set of prescribed clauses as well on their resources section of their page. And you'll also find a good sample of arbitration clause in almost every institution's website as well. So like MCIA will have what they believe is the most appropriate reference clause. And likewise, you will find a similar clause in SIAC and LCI and stuff like that as well.
Very well, sir. Question number 2 coming your way. In case of an institutional arbitration, how are arbitrators appointed? Is it done by way of party autonomy, where parties decide, or it is in-house institutional arbitration center rules that decide who the arbitrator will be?
Yeah, so I think the best way to answer that is parties nominate, but the institution appoints. So yeah, so I think most institutions reserve a role there. And so it's safest to say you can nominate, but the institution will accept and appoint.
Going ahead with our next question, what are the major impediments to the enforcement of arbitral awards, especially in the context and scenario of international arbitration?
Right. So, well, let's take a sort of closer to home assessment first. You would find here our biggest problem is the amount of time it possibly takes to execute or challenge an award. So just to give you all, I think I mentioned it in passing, the final award in the Arbitel versus HSBC judgment was passed, I think about 5+ years ago, and it is still pending execution in the Bombay High Court. It lists very frequently, so it's still pending again. But though, like I said, because there was an emergency arbitrator appointed there, those the effects of those delays were. It's great foresight from the lawyers if you think about it, knowing that execution is going to be a problem, knowing the nature of your opponent, you bring these proceedings and you get protective orders early and get court assistance early, and it sort of mitigates against that. But of course, delays in court is the greatest challenge. The other challenges you can have are particular formal requirements associated with the jurisdiction in which you want to enforce an award. So a well-known example from a short while ago, like I think it was in the 2015 uh, time frame, court in Dubai refused to accept an award as being valid because a statement of a witness on oath was not affirmed in accordance with the local laws. So you can have a very peculiar sort of reason for a court not enforcing an award. So arbitrators are also required to be mindful, and institutions also are required to be mindful of the laws in the jurisdiction in which you're going to be seeking enforcement, and the award should meet that standard. The proceeding should meet that standard as well. Like so. So I think those are the. I
Yes.
think a new way of defeating awards is also going to be cryptocurrencies and things like that. So you're going to have assets transferred through wallets,
Oh,
and yeah, that's an emerging jurisdiction in. There's specialized practitioners in tracing assets through cryptocurrencies and all that. So that's another developing area of law. So people using online, very anonymous sort of accounts to pilfer away basically the potential recoveries.
that seems to be an interesting topic for another discussion,
Possibly.
this session, and we would love to have you over for that. So now, sir, next question, going ahead with the next question, with the advent of technological advancement, how are virtual hearings and artificial intelligence tools affecting the landscape of arbitration?
So, do you have a pro AI sort of approach for yourself personally? Like, what are your thoughts on AI?
Personally, I don't. I'm still a very traditional mindset lawyer. I prefer the book in my hand and scribbling notes and on it, and that is how I've always functioned as a lawyer. So, personally,
So,
I'm not. Yeah.
yeah. So, like, whenever I hear AI, I kind of think of simulation theory, and it's a topic that I've been reading about a lot actually recently. And well, simulation theory basically believes that we are all role players in some game, right? And life is basically a simulation, and we're living through this sort of simulation. Now, I'm not as kooky as that sounds. Think of it in another way. When you have AI sort of playing a role in an arbitration, a question that really does come to mind is whether you are um, in control of those proceedings at all. So when it comes to like to use a game analogy is, are you a role player or are you a non-player character in this simulation? So is is your advocacy even making an effect on the AI who's adjudicating the process, or is it it doesn't matter. Like, it's a foregone conclusion, and the decision is taken by whoever manages that AI system, and it doesn't have to be the arbitrator. It could be the prejudices introduced through the code that is written for that AI. So I'm very hesitant about AI playing any adjudicatory role in an arbitration. I'm also aware, of course, that that's not its only role. People use it for uh, as a search assistant. So they will use it to like sift through large volumes of evidence and all that sort of stuff in pre-trial stages. But even there, I don't know whether it captures effectively sort of interpersonal relations and normal patterns of communication between persons and irregularities in those patterns. So when you're presenting evidence in a trial or in an arbitration, it's not the volume of the evidence that matters. It is building a story through that evidence that matters. And I don't really know whether technology can do that. Technology can certainly provide you some amount of assistance in doing that, making perhaps your job less cumbersome. But I believe that is a human task, and it is a human to human sort of storytelling process or a evocative process that only advocacy can do. So I don't really have a pro AI sort of approach there as well. When it comes to virtual hearings, I actually have a very pessimistic outlook towards virtual hearings as well, because I feel the entire the joy of sort of experiencing an excellent advocate is lost, because like I've always felt like really good advocates have an aura about them, and that aura is not transferred through sort of a virtual platform, though we are in a virtual platform. But like I feel like there is something missing there, and it does impact, I believe, the client's right to effectively present their case in some sense. It may not be like, it may be a solution that meets a need, but it fails to meet that need perfectly. So if we're looking at building a perfect process, then I don't think virtual hearings are the perfect process.
Now, sir, what are the most important and landmark legal reforms in international arbitration law that law practitioners like us should be aware of?
Right. So I personally feel it is consolidation proceedings. So where you combine more than, I don't know if it's a novel process, but I find this the most interesting sort of development. It's a borrowing from general litigation where, you have maybe two or three trials happening before the same arbitrator. So this sort of joinder of causes, which is a general litigation sort of strategy, but I'm very happy to see it adopted in arbitration because it makes it so much more meaningful. You know, very often companies are actually shell entities. So, proceeding against a company in an arbitration that ultimately no recovery can be made against that entity is quite meaningless. So you want to look at the real sort of the ghost behind the machine kind of you want to make a meaningful recovery in an arbitration if you're a claimant. And I think this is a great development, like, and it's actually quite foreign to the concept of arbitration, because arbitration sort of depends upon consent. And I think this is an evolution of our understanding of what consent is, which benefits the process when done correctly, of course.
So, what are the factors that parties should consider while selecting a particular institutional arbitration center for the purpose of arbitration, and how do these institutions differ in their procedures and rules?
Mm. So I think the biggest contribution right off the bat of an institution is in its role in appointing the arbitrator. So are you familiar with this process of scuttlebutt? Like, it's an investment sort of, it's suggested by Napoleon Hill when he talks about how you go about making a good investment. So I believe like this is a tactic that is important here. You want to build your knowledge about who is getting appointed by institutions and perhaps why they are getting appointed by institutions as well. So who are the arbitrators that are being appointed? Because that is ultimately the adjudicator of your case. And any negative chatter here is something that should sway you away from an institution. So, for example, if an arbitrator is appointed by an institution, but that appointment is questioned successfully in an award challenge stage or at any other stage in the proceeding, that arbitrator is set aside or the appointment of that arbitrator is questioned. I think that's good reason to stay away from an institution. Because there's something wrong with that decision-making process. They've not contributed effectively to administering that process. You want to look at the experience of the people running the institution as well. Because if you think about it, a sole arbitrator is in the slide that we saw. So arbitrations, ad hoc arbitrations seem to have the preference of about 30% of people in construction arbitrations. These are complicated disputes. So if people can trust complicated disputes with an ad hoc process, I'm looking for a further value add when I come to an institution. So what is that further value add? I'm looking at the registrar's experience in handling multiple proceedings successfully. I'm looking at prior users' satisfaction, perhaps. Are they happy with how those proceedings were conducted? And I'm definitely looking at the experience of the case managers. So I'm all for young lawyers, but if you have very, very experienced arbitrators and very, very young case managers who are perhaps interns, I've seen this situation as well. There's going to be a conflict there, and there's going to be a power dynamic that doesn't allow anything meaningful to happen. So yeah, I think those are things that you would keep in mind as well. That are they actually effectively managing the dispute? Then a lot of arbitrators use tribunal secretaries. Now, people's views on this are very divergent. Like tribunal secretaries have in international commercial arbitrations even authored the award, and you know that's quite a scary sort of situation, I believe, from a participant's perspective, because that's not who you appointed, right? You didn't appoint the tribunal secretary. The tribunal secretary is appointed either by the institution or by the arbitrator himself or herself. So who the tribunal secretaries are, what their experience is, also becomes very relevant, because they're this sort of unappointed arbitrator involved in these proceedings. So that's another thing that I would keep in mind. But that could be common even in ad hoc arbitrations where arbitrators appoint their own tribunal secretaries. So
Very well. So, sir, what strategies can be employed to manage the costs of arbitration effectively and make it cost effective?
so a lot depends on the efficiency of the mechanism that you've provided for in your arbitration agreement. So I would always suggest sole arbitrator. I've never come across a dispute that required 3 arbitrators. This is my personal perspective. Lots of far more experienced practitioners will tell you otherwise. But I think they're speaking from their experiences, and my experiences suggest otherwise. Even in a technical arbitration, like you can take a number of fields: construction arbitration, engineering arbitrations, maritime arbitrations. There are certain insurance contracts, the adjudication of which only goes to this sort of very limited body of arbitrators. Even in those cases, I believe if expert opinion is required, expert assistance is required, it's not necessary for them to be on the tribunal. The arbitrator can always appoint them through the institutional rules as experts and consult them. In ad hoc arbitrations, you can always have an expert offer evidence and play a role in assessing evidence that is on record and stuff like that. You don't need more than one arbitrator, in my opinion. This is just my opinion, and I believe it is far more cost effective. And some sort of reason has to be prevailing in the users of arbitration, which is why 30% of construction arbitrations, which are complicated cases, go to ad hoc arbitration. So institutions need to do far more, I feel, to justify their fees in this sort of setup. Like, people are making a very conscious sort of decision to not go to institutional arbitration, even in complex cases.
Yes.
So I think that's the advantage of having a good, effective mechanism and a sole arbitrator, perhaps. I think choosing the right arbitrator is another thing that can really, really benefit you and save costs. So, common complaint, again, this is scuttlebutt, common complaint that I get from other colleagues and stuff like that is that the arbitrator is a busy counsel running around in court and therefore cannot dedicate time to the arbitration process. And procedural directions, awards, orders, all of that gets sort of delayed because that's not the priority for the person. The same thing about retired judges and stuff like that. So I think it's now, if we want to get serious about our jurisdiction being uh, pro arbitration, we need to have practitioners take this decision of, I am only an arbitrator.
Yes.
I am only an arbitrator and this is all I do. And I think that reassurance to parties will help them make a decision in appointing the right arbitrators and saving costs there as well. And of course, like in all proceedings, the choice of your lawyers will play a role as well. I don't think we need senior advocates in most proceedings. With the quality of legal education that we have today, as opposed to like even when I graduated, like younger lawyers are so much. In fact, I just judged a moot court, and this is something that I gave them as feedback, that they were far better than I could ever have been at that stage. And strangely enough, they were all debating a subject that none of them had actually started studying yet. So I genuinely believe, I'm not saying that for any brownie points, I genuinely believe that having a young small team is far better than having a cumbersome big team and engaging seniors when they are not required. You can, of course, I mean, choice of counsel is a personal decision, and it's something that party is obviously free to make. But then, even when you make the choice, senior is not required throughout every stage of the proceeding. So you can reduce costs even there. Like it's not necessary to incur those heavy expenses for every stage meaninglessly. Then you are yourself to blame for the expenses. And I believe lawyers have this role of advising their clients appropriately very early on, or as early as possible, about the prospects of their case. So sometimes a client will come to you and you believe, you take what they are saying at face value, but then when the other side presents their side of the story, it becomes pretty apparent that you're going to be on the losing side. And serious consequences may also follow. I think it's appropriate to advise your client on prospects. Like, a lot of people, I believe, give this sort of I can pull it off kind of, belief to their client when it's not possible. And I think that saves costs. You can have younger lawyers trained in other ADR skills like mediation, negotiation, and use those skills to sort of mitigate sort of the outcome, have a better sort of mediated settlement or a negotiated outcome instead of having a punishing award passed against you with full costs. So that's another strategy you can use. And lastly, I think if we build this culture of actually awarding costs on actuals, as I would say. So if the successful party was successful on 100% of its claim, award 100% of the cost that they have actually incurred. And I think what that does is it stops people from trying their luck in defending proceedings, which should not be defended, should be settled. And it also, if you award costs on the degree of success, I think what that encourages is people to make realistic claims and realistic counterclaims, and not, sort of push this sort of belief that if I counter whatever they are asking for with a figure like this, uh, we'll meet somewhere in the middle. Those are all unrealistic bargaining tactics or litigation tactics, and I think they they are effectively negated by an award of full costs. Of course, the fees of the arbitrator also depend upon the quantum in claim. So that's another reason to have reasonable, realistic claims. So it helps reduce the arbitrator's fees when the fees are governed by a schedule or by institutional rules as well.
So what are the factors that generally influence the choice of the parties between institutional and ad hoc arbitration?
Right. So I think cost efficiency,
Yeah.
uh, because of the flexible nature of ad hoc arbitration, um, and the procedural uncertainty in a sense, because parties haven't predefined the process. You're taking decisions sometimes on the fly as you go. Those lead to overruns. And, you also have issues with now going back to court for adjudication of documents, for stamp duty and things like that. All of these are unknown expenses or unanticipated expenses that prolong the trial and prolong the hearing. And um, it it's a reason to like go to institutions, because this may be something foreseen by the institution when you invoke, and they can forewarn you that, look, I can't look at this arbitration clause because it's contained in a document that is insufficiently stamped. Get it stamped and then come back to us, and you've sort of avoided this whole delay, and you can start the process appropriately right at the get-go. Great advantage is sort of the publication of a list of specialized arbitrators. So this if you study firm theory, this is known as a reduction in search cost. So the greatest expense in time and money is actually finding the right arbitrator. So if that is already being done to some extent by the institution, um, when you look at their website and you can find domain specialists, the search costs associated with finding that arbitrator are reduced drastically. You will have published data on their track records. So how many awards have been challenged, how many appointments have been challenged, things of that sort. And you know that their success rate. If you ad hoc arbitration, I don't think has that database available against every arbitrator. So it's an unknown in that sense. And what effect they have, all of these factors have in a particular case, also depend upon your choice of arbitrator. Because while I understand the efficiencies that institutional arbitrations can offer, arbitration is ultimately all about the arbitrator, and an inefficient arbitrator can be conferred upon you through an institution as well. So It's really it's that choice that sort of governs everything. And when I say efficient arbitrator, I don't necessarily mean efficient with the process and being very speedy and things of that sort. Sometimes a certain amount of discretion is a sign of great intelligence and valor also. So understanding that allowing a delay at a particular stage to allow parties to do something, whatever it may be, like, meet some sort of evidentiary need, is not a sign of inefficiency. It may be a sign of great foresight because you prevent any challenge to the award on those grounds. So you're saving time in challenge proceedings by being efficient in the manner in which, and sensible and having foresight in how you conduct the proceeding. These are all sort of things that arbitrators decide. And in my opinion, ad hoc arbitration allows you to make those decisions much more flexibly, and it can save costs as well. So I don't have a bias towards either. I have a bias towards the individual involved. And I believe like the individual sort of is more important than the process.
Very well, sir. Sir, according to you, which is the most popular and most preferred institutional arbitration activities?
Okay. Sorry, the question was, what is the most preferred institution?
Preferred and most popular institutional arbitration center for parties.
So in India, the data seems to suggest DIAC, the Delhi International Arbitration Center. So if you go to their website, they actually have a website. They have a daily cause list. So I think that in itself sort of should give you this sort of reassuredness that they are in fact very, very successful. They have about 30 cases listing every day. So they're very well supported by their parent High Court. I think the Delhi High Court does a great job in promoting arbitration as well. Internationally, there is absolutely no doubt in my mind. It is like hands down the American Arbitration Association. It was formed in 1926 and has till date done past 83 lakh awards. So that's about 85,000 a year. So that's an incredible sort of institutional story. Like, and it's not the only arbitration center in America. It is the most prominent one, but it's not the only institution in America. You also have the California Arbitration Center, you have the New York International Arbitration Center, you have JAMS, you have Arbitration Place. JAMS is a close second, and I believe they do about 9,000 arbitrations a year. So these are really, really high numbers compared to the numbers that we saw in the slides earlier. And I think a lot of people don't give the American arbitration community its dues, but they are far, far ahead of everybody else, I think, in the prolific volume that they do for sure. And of course, the progressive mindset that they have on arbitration as well. They allow a lot of subject matters to be arbitrated, including patent disputes, which I find very interesting because we consider that to be a subject that only state-appointed tribunals can decide, and they don't hold that view. So you can take an award of an arbitrator saying that you are the lawful holder now of this patent, or your invention was not anticipated, and you can seek the registration or recognition of your patent on that basis. So, of course, LCIA and SIAC and HKIAC have a very, very respectable caseload, and they're very well managed institutions with no amount of controversy as well associated. So I think these are great, great sort of institutions. They would be party preferences depending upon usually where finance comes from. So usually the financing party decides what the seat will be.
So what is the difference between governing law clause and rules stipulated in the institutional arbitration manual? So there is obviously a clause, that's the governing law, that decides whether it is English law or Indian law. And on the other hand, there are rules that are enshrined in the arbitration manual of that very institutional. So what happens when there's a conflict between the two? What will prevail?
So I have a slide I can share with you for that.
Oh, wonderful. Please, if you can now.
Yeah. Yeah. So yeah, is this visible to you?
Yes, it's visible, perfectly visible. Yeah.
Yeah. So here the clause that I've prepared for you contemplates arbitration seated in London, England, under the UNCITRAL rules. So this is an ad hoc arbitration, but it has adopted the UNCITRAL rules, and the rights and obligations of the parties will be governed by the Convention on International Sale of Goods. So these are your respective laws that apply to this dispute. The law of the seat is London, England, so English law. The procedural or the adjective law of the dispute is UNCITRAL arbitration rules. So that will guide the process. And the rights of the parties will be decided as per this convention. Now, coming to your question, if there is a excuse me, if there is a conflict, how would you go about resolving this conflict? So you would go, since the UNCITRAL arbitration rules have been adopted, okay, what would you do, for instance, in a situation where the Convention on International Sale of Goods did not cover, for example, some aspect of the claim or the dispute that is before the tribunal? So now you have a failing of the chosen substantive law in that it does not address the dispute completely. So here the arbitrator will apply Model Law 28 and enter upon an inquiry to find out what is the applicable or appropriate law given the failing of the party's choice. So this would also, if this was institutional arbitration, most rules would also allow the arbitrator to carry out this exercise. So here it would be the arbitrator would decide in accordance with English law because that is the law of the seat. So most case law, and I can tell you a prominent case law is NTPC versus Singer. So it's a 1992 3 Supreme Court cases, page 551. Here, the law of the seat will govern, and conflict of law rules will not apply. So the parties have, by their choice of the seat, decided that the dispute should be governed by English law. So that's one way of resolving an anomaly. Another anomaly, as you mentioned, would be perhaps if there is some sort of internal conflict between the UNCITRAL rules and maybe the laws of England. I don't think they should be, but that could be a possible conflict. Again, the arbitrator would, under Model Law 28, have to enter upon an exercise. And of course, I cannot answer this question because we don't have the facts before us. But on the facts of that case, what is the applicable appropriate law to decide the particular question that comes up before the arbitrator? So the procedural rules in that sense allow for the arbitrator to enter upon assessing that conflict. So you would decide what is the appropriate law to answer that question. So I think that is the answer. The best answer I can give you is there are certain questions which will be substantive, and there are certain questions which will be procedural. And depending on the nature of those questions, there will be an appropriate law. So you would apply what is best and most appropriate for that particular type of question.
And sir, lastly, you have been a tremendous source of inspiration for me and many. Who was your mentor, if you ever had one? And what would be your piece of advice for all the law students and lawyers who wish to build a successful career like you have in the field of arbitration?
So thank you for that. It's quite humbling actually. So I'm really blessed to be to have the parents that I do. Like they've had very difficult lives themselves, but they've given me the perfect life. So I've never had to look far for my mentors. In the legal profession, of course, it's Mr. Madan. I was in his chambers for 7 years, and every opportunity that I've got comes from being in his chambers. So those are my mentors. Advice I would give people, firstly, I would reassure you that your journey will be beautiful. It doesn't have to match my journey. It doesn't have to match anyone else's journey. So that's the advice that I would give.
Fantastic, sir. What a session it was. Not just one of the longest sessions ever recorded, but one of the finest that we have ever recorded. I once again urge and appeal to all young lawyers, law students watching this to maintain a separate diary on arbitration and note down, pen down everything that you've seen visually and in the form of PowerPoint presentation, because this is definitely going to help you and take you places. Thank you so much, sir, for taking out time for doing this comprehensive analysis on arbitration essentials. And it really means a lot to me and my team. Anything that you wish to say as parting words before we wrap this up?
Thank you. Actually, like I said in the beginning, I think what you've built is a great repository of information, and it should be the new way of teaching people.
Grateful for all the kind words. So next episode, it's on its way. It's goodbye for now.
Thank
Thank you.
you. Bye.